State calls us next witness.
Your Honor, at this time, the state rests.
All right. State is rested. What time is it? 11 o'clock. You're going to need some time to get some witnesses here. Come on. Go back to the jury room for just a little bit, okay? And we're going to bring it back out and make some decisions how we're going to proceed with the trial anyway. But I've got some stuff I got to take care of out here for a minute, okay? All right, I believe the defense will have a motion at this time.
I do, Judge. The state having announced that the state rests comes now the defendant, Jeffrey Dean Spence, and respectfully moves the court to enter an order of directed verdict of not guilty. And in support of that motion, I will say the following. We're here on a murder case happened in Tippah County, Mississippi, on or about November 30th, 2022. The question remains after the government has had all week to put on evidence. The question still remains: who killed Kirby Carter? Who killed Kirby Carter? Could have been just about everybody in Tippah County, and we do not know, and they have not proven to the most minimal legal standard that Jeff Spence had anything to do with it. Jeff Spence has not had anybody place him in Tippah County, Mississippi on November 30th. Nobody has placed a murder weapon in his hands. They have no proof in terms of fingerprints. They have no proof in terms of any standard forensic evidence. The question remains, as I stated here, who killed Kirby Carter? I don't think the state knows. I don't think the state will ever know. And I think when I told the jury on Monday that they selected somebody to be an accused, that's exactly what we have. We have a selected accused person, and they haven't proved beyond a reasonable doubt that Jeff Spence not only is guilty, they haven't even proven that he has anything at all to do with this case. He was in Tippah County in Kirby Carpenter's home for weeks. He and his wife helping with the newborn baby. They undisputedly left Tippah County Tuesday afternoon, November 29th. Arrived home in the southwest Virginia area around 2 or 3 o'clock in the morning on November 30th. We have a electronic message rendered from a conversation actually between Caitlin Spence and Karen Spence, Jeff's wife, and Caitlin's mother, at about 8 p.m. on November the 30th. The subject of that conversation is what Dad had been doing today. He's worked in the yard, he's worked inside, he's grilling hamburgers. Apparently he's good at hamburger grilling, and the next sentence from Caitlin is, well, I know how much you've missed his hamburgers because they've been in Mississippi so far. The conversation is obviously about Jeff Spence, and he just got up from a nap and worked hard all day and was fixing hamburgers for supper, for dinner, because that's in response to Caitlin's question, what are y'all having for dinner? That place is, he's not cooking dinner at Kirby Carpenter's house. He's cooking dinner in his own house in Virginia. There's just nothing to tie him at the operative time here. He didn't cook dinner in Virginia around 8 o'clock and kill Kirby Carpenter at 7 o'clock. It's not possible. It's too far. It's 800 miles. 10 hours. That's the truth. Other proofs, like the trash we just got through hearing from an estranged daughter full of animosity and hate, doesn't mean that she didn't place it. What she's talking about is 10 years ago, not now, not 2022. And other than her, they don't have any witnesses that ties to the property, ties to the deed, ties to anything, ties to this case. It's a case that merits not going to the jury, and I'm asking the court to give us a correct verdict tonight.
All right. I'll hear from the state.
We state submits that we proved the case. Court obviously has to take this in the light most favorable to the state. And we've had testimony that contradicts everything that Mr. Hill has said, primarily through Caitlin, who had a conversation with her father, where he admitted to her that he killed Kirby Carpenter. Not only that, but we have Kirby's property in his possession, custody, and control. And, the taking all the proof in the light favorable to the state, with all the testimony that has occurred, the investigation, the witnesses that have taken the stand, this man stands before the court as the state has proven each and every element of the property.
All right. Every time I have a criminal trial, I make me a checklist of what elements there must be proof of, and I've done so in this case. I think the state has made a prima facie case as to meets all those elements. They've ID'd the defendant, they've established venue, they've established that Kirby Carpenter was living, and they established that Kirby Carpenter died, and when that took place, it was a result of a shooting, and there's evidence of a robbery had been set forth, and I'm going to deny your motion for a directed verdict. There's been some evidence on every element of the crime charge, and it'll be up to the jury to decide if that some evidence is enough evidence, and we will. That'll be the jury to make this determination. Do you need a minute to y'all talk and decide how you want me to proceed as far as the defense case? Okay. Do what?
We'll do so right now.
Y'all do that now anyway, okay? You can use my chambers if you like to.
Well, I think we have.
Wherever you want to. Y'all just
Judge?
yeah. Mr. Spence, these comments are directed to you, not necessarily to your attorney. At this time, the state has announced that they have rested. In other words, now it's time for the defense to put on any witnesses if they want, and those witnesses can include you. I want you to know that you have the absolute right to be sworn in, sit in the witness chair, and testify if you like to. The decision about whether you wish to testify or not testify is your decision, and your decision is alone. I would encourage you to consult with your attorney in making that decision, but if you want to testify, myself, the district attorney's office, even your own attorney cannot stop you from testifying. You have the absolute right to testify, and you can if you wish to. On the other hand, if you do not wish to testify, no one can make you testify. I can't. District attorney's office, your own attorney cannot force you to testify. If you do choose not to testify, the jury will be instructed that the fact that you did not testify cannot be used as any evidence whatsoever that you were guilty of any crime, because we all have the right to remain silent. But whether you choose to testify or chose not to testify does not change the fact that the state bears the burden of proving that you are guilty, and you never have to prove that you're not guilty. Do you understand that?
Yes.
Have you consulted with your attorney and reached a decision on whether you wish to testify in your own defense or not?
I did consult with my attorney.
Have you made that decision?
I have.
And what is that decision?
I do not want to testify.
All right. Mr. Hill, do you agree with y'all had a discussion on that and reached that decision?
We have discussed it more than once over the past several months, more than once today, and we are on the same page, yes.
All right. All right. At this time, I'm going to bring the jury in. Do you wish to call, does the defense wish to call any witnesses?
No, sir.
All right, I'm going to let you bring the jury back in. I'm going to let you rest in front of the jury. And I think we've all agreed that we've got a lot of stuff to do on jury instructions and preparing closing arguments, and I have caught us a little, I think all a little about surprised how fast we've wrapped up here today anyway. I'm going to excuse the jury until 9 o'clock Monday morning. We'll come back then, have jury instructions ready, be prepared for closing statements, and begin deliberation, okay? We'll talk about how long, let's talk about jury instructions after, let's talk about them shortly, then go to lunch, and then come up and finish jury instructions after lunch, okay? All right. Having rested, it's now the defense opportunity to present witnesses if they choose to do so. Who would the defense call as its first witness?
Your Honor, at this time, I'm announcing for the defense that we rest.
All right. That means you've heard all the testimony you're going to hear in this case. Quite frankly, we're not ready for your closing arguments and jury instructions. We're going to have to, we'll spend a good bit of time getting jury instructions together and letting these people form their closing arguments. If we got that done, it'd probably be 5 or 6 o'clock this evening before you got to start deliberating. I'm not going to make you work at 5 o'clock on Friday afternoon, start your deliberation. What I'm going to do, you got...
Your Honor, just for the record, same time on rest.
Okay. I'm going to let you go home. Be back in the jury room at 9 o'clock in the morning. Not in the morning, excuse me. These Monday morning. I voted for tomorrow. I voted for tomorrow morning, but I got outvoted by everybody at the courthouse anyway. Somebody want to go to ball games and such as that anyway. But be back at 9 o'clock on Monday morning. Always something. I'm going to ask you to be back in the jury room at 9 o'clock Monday morning. I want you to pay special attention today. You've got a long break between now and Monday morning. Stay away from the news, anything you see pop up on Channel 9 or Facebook or any website, or meeting somebody on the street that said, I heard you had jury duty, what do you think about it? You've got to avoid it. You don't form any opinions, don't express any opinions, don't talk about the case, don't even let anybody talk about the case with you. That includes your husbands and your wives, your kids, anyone else. Don't attempt to investigate the case. Don't go home and Google anything. Don't look up any law. Just leave your mind just like it is now. Know what you know when you come back Monday. Know what you know right now, and not anything else. Don't think anything. Just keep your mind. Keep away from anything. And I know I can count on y'all to do that. There's 3 of you. There's alternates. I'm going to ask y'all to come back too, because if one of the original 12 were to get sick over the weekend, I need you there as backup still anyway. Y'all, I'm going to let you go out. Nobody in the jury I don't have any reason to think, suspect in any way that anybody would try to contact you about your jury service. If they do, you let the court know about it, okay? Thank y'all. See y'all Monday morning. All right. Because it's not quite. Let's spend a few minutes talking about jury instructions before we break for lunch. Anyway, the members of the audience, this isn't get real boring real fast. You're welcome to go if you like to at this time, but has both sides received the court's instructions? They are they're the court standards instructions been used in this district for 40 years at least. I don't know if in the court's instructions we included, I think it's C7, I think, that deals with the defendant's failure to testify. If they don't, I'll include that anyway.
I don't think it was in there. I think there was only 6.
Okay.
I have a position on that jury instruction.
Okay.
And I would like for it to be that way.
Okay.
I don't want that.
Okay. You don't get it. You don't. That's always that option. If you if you don't want it, you don't get it, and it's some different attorneys have different theories on that, and I think both of them are legitimate arguments anyway.
There's a provision in one of the state's instructions that basically covers that.
Okay. If you don't, whatever C6 or C7 dealing with the defendant's failure to testify and not being used against you, if you don't want that, we just won't offer it, okay?
Yes, sir.
All right. So I don't have. Let me see if I got my instructions. Have been filed. I think they've been filed. I'm gonna just cut right to the chase anyway. Has anyone offered a lesser included or intend to offer any lesser included?
We did.
You did not?
No, but I wouldn't be completely fair to my client, I guess, if I didn't.
Y'all talk. Why don't y'all spend these next few minutes? I think that's going to be the main issue. Most of our jury instructions, I think, will be fairly straightforward, and I think I think whether or not any lesser included are going to be offered is be the only sticking point we might have. And why don't y'all just take, let's do this. Now, let's go ahead and y'all go ahead and talk about it now if you want to, okay? And can I get a copy of the state's instructions? Brooke probably has those. Are they here, Ms. Sanders? State's instruction and defense proposed instructions. What's that? I've got volume. I got something. I don't have the latest. I got the first volume, not the second volume. Anyway, if you go get off my desk, I'd appreciate it. Okay. Yeah, you go wherever y'all feel comfortable, okay? Yes, sir.
Just for the record, the defendant, Jeffrey Dean Spence, does not request a lesser included.
Okay. All right. All right. Let's, Mr. Tracy, do y'all have the court, all the instructions there? Yes, sir. All right. All right. The court has proposed court's instructions 1 through 7, with number 6 being withdrawn, dealing with the defendant's right to not testify. Does anyone have any objections to court's instructions 1 through 7?
Not from the state.
All right, I'm going to give court's instructions 1 through 7. They're the ones we're always give, with the exception we added 7 dealing with note taking. That tells them to rely on their own notes and not anybody else's anyway. Let's look at the state's instructions next, that being the first one being S1, which will be a elements and form of the verdict instruction. I generally like to give those two together. Is S1 offered?
I'm sorry?
Is S1 offered?
Yes, sir.
Is there any objections to S1? Sets for the elements and form of the verdict. All right, S1 will be given. S2 is appears to be a elements of the crime of robbery. Is S2 offered?
Yes, sir.
Any objection to S2? No objection to S2. S2 will be given. All right. S3, I haven't read yet. Is S3 offered?
Yes, sir.
Let me. Any objection to S3?
We object to the instruction that as it's drafted, it's not correct.
Tell me what the problem is anyway, and y'all, and the state be getting me up some law to say why you think it is correct statement of the law. first off, let's make a decision about whether it is a correct statement of law or not. And I'll give both sides an opportunity to express what they feel of whether or not it's a correct statement of law.
My position is that the robbery has to be first, and if the murder occurs during the commission of the robbery, then capital murder.
That
Robbery can be a predicate
if
offense,
you,
but it's got to occur first.
what the question basically being, if I get mad and shoot somebody and then steal their wallet, is that capital murder or not? You know, or do I go there with the intent to rob them, and then if person A and person B gets into a heated dispute and person A shoots and kills person B and he says, well, I might as well get his wallet while I'm here, is that capital murder?
I think the intent has to be there to commit the predicate offense. The intent has to be there to commit the predicate offense. And the classic example that I've defended dozens of times is John Doe goes into a convenience store or a liquor store with the intent to rob. And things go sideways and the intent to rob then ends up with a gun and there's a murder as a result. That's capital murder, okay?
As opposed to, I go in to buy a pack of cigarettes and get into it with the store clerk and shoot him, and then decide to steal something while I'm there. I want both sides to present their arguments as to what the law is on that case. Anyway, I don't want to make that decision on the fly. Anyway, that issue has been addressed by the Mississippi Supreme Court on several occasions. I believe I know what the answer to that question is, but I want somebody to support that
This
decision.
instruction in advance until Monday morning.
What's that now?
Are we holding this instruction in advance?
I'll give you a chance to either look at it now, but I'll give you the opportunity to address it on Monday. If you,
There is law.
there's law on it. I think it won't take me just a minute to find out, but I'll give you an opportunity. If the state wishes to address it now, they can, but I'll give you an opportunity to.
Yes.
I'd rather you not wait till Monday. If you got a case that says otherwise, get it to me sometime before Monday, okay? Send it to me before Monday, okay?
We'll do the same.
Okay. I don't want to make that decision Monday morning. I'd rather beat both sides address the issue, and I think it is.
It's been answered.
You what?
It's been answered.
It's been answered on many occasions, and I'm almost certain I know the answer, but I want y'all both to have an opportunity to correct me. So I'm going to hold S3 in abeyance until y'all give me a chance to rule on it. All right, so that's all the state's instructions this time.
I do believe that we'll have
Yeah, it was in the intent. It's right.
What's that now?
If I have service, I think I can answer that question in about 5 minutes.
All right. Well, I'll give you an opportunity to. Does this, when I live here today, I don't want the jury be waiting Monday morning for us to still be arguing over jury instructions. If you got any, does the state anticipate any further jury instructions?
No, it's
All right. Let's
today, I'll let you know.
all right. Let's move on to the defense instruction D1. Is D1 offered? D1, is it offered?
I don't know that I have defense instructions.
I can run and get you a copy right quick if y'all need another copy. All right, we got a copy. D1 has been off. I'll give you the opportunity to look at it and see if you've got an objection.
Your Honor, it's in the elements instruction that we have to approve on November 30th of 2022, Jeffrey B. Spence did this and that, so it's already in the elements.
I think there is a, there again, I think there's case law on whether an alibi instruction gets its own instruction or not anyway.
Okay. We need an opportunity to look at that.
I want one or two.
That's what I say. You're probably gonna get one, either, you're probably gonna get either or, but not both anyway.
And I don't want both, I want one of them.
Okay, y'all, y'all compare one or two in conjunction with each other, state.
Can we get back to give us time to do some research on that?
I'll give you opportunity to, but I would like to, I don't want us to be arguing about it Monday morning, as long as we're, y'all can work as much this afternoon as or tomorrow as you want to, but I want to reach the decision before Monday.
Well, and we can send you support.
Y'all send me some forward anyway. But I'll be consider either D1 or D2, but not both anyway.
Yes, sir. Yes, sir.
Okay?
And I will, is it okay if I send you information Sunday afternoon? Is that
That'll be
soon-
fine.
is that
That'll
soon
be
enough?
fine.
Is that
I'll
soon
be,
enough for the court?
if y'all will send me any information y'all want on these jury's questions on Sunday, I'll tell you what I'm gonna do Sunday. So y'all be prepared, okay? Let's move on to D3. I'll be expecting y'all's commentary on S3, D1, and D2 before Monday, all right? Let's move on to D3 anyway. It's often offered anyway. D3 I assume is offered. What's the state's comments on D3? It is, I assume.
It's confusing, talk about reasonable doubt, more probable, way the evidence, and that's covered in the course instructions. We, way the evidence, conduct, instruction. I don't think it's problem.
Any word in support, Mr. Hill?
Judge, I cited,
There are cases that have approved it. There are cases that says this is your classic two hypothesis case, and there are decisions, I believe, that says it's okay if the judge gives it, it's okay if the judge don't give it. I traditionally don't give it because I think it's just adding more language to the jury's decision to weigh all the evidence and decide it based on all the evidence, the totality of the evidence. And I think it's in the court's discretion to refuse or grant, and I'm going to refuse D3. While it's not error to grant it, it's also, court's opinion, is not error to refuse it. And I just think it's just adds complication to the jury's duties anyway. All right, that brings us to D4. Any objection to D4?
It's covering the court's instruction, it's covering our elements instruction.
Which court instruction is it in?
To me, the D4 is very akin to, has elements of the court's instruction 6, which I'm not given, where it says not required to present evidence. When it says Jeffrey Spence is not required to present evidence or prove anything, that it's akin to the C6 anyway. So I'm not giving C6.
The CC3 is law presume every person charged with commission of crime against.
It does have the added element of not required to present evidence or prove anything, which normally would be covered by C6, which we've withdrawn. I'm going to give D4 in lieu of C6, basically. D5.
Repetitive, cumulative, pile on, what we call it.
I'm going to put D5 up there with D1 and D2. I'm not I'm not going to give all three of those. Those are interrelated. The top half of D5 is, I think, covered by the court's instructions. But dealing with the alibi, I want to see if alibi is to be treated separately other than this general burden of proof. And if so, if it is, I'll let you have one alibi instruction.
One alibi, at least one alibi instruction.
I'm going to let y'all analyze D1, D2, and D5 as a package deal and see if y'all can come up with one instruction dealing with that anyway.
So,
I'm not saying that I'm going to give an alibi instruction. I believe I will, but I think the law allows that. But I'll just give just my intention to give one alibi instruction. D6. This is often offered.
sorry?
This is often offered anyway. Any word, any opinion on D6, Mr. Hill? I know it's off and off.
Well, it's a correct statement of the legal principles covered there, but it may be covered in the court's instruction.
It is covered in court's instruction. I'm gonna refuse D6. I've already covered it, and I take the opinion that don't just keep on harping on anything. Get the jury confused. All right, D7.
Just like D3.
That's D3. That's your back to your two interpretation. That two interpretation rule, and I traditionally do not give that. I think it's best that the jury just instruct them on what reasonable doubt is, and I traditionally don't give them. It's not required to be given, and I generally refuse them as just adding more layers of complication to the jury. All right, D8.
It's not the law.
And it's covered, should be covered in the instruction.
Let me read it right quick. I have. Of course.
How the jury is to evaluate the evidence.
The Supreme Court the Supreme Court did a few years back reverse 100 years of common law and say that in Mississippi you're not entitled to a circumstantial evidence instruction anymore. This instruction had been given for the last 150 years in the state of Mississippi, but the Supreme Court has specifically said it should not be given anymore. And the
Should not
evidence,
be, or is it up to your discretion?
what's that now?
Should not be given, or is it up to your
It
discretion?
said should not be given.
So you don't have it.
I don't think I have the discretion. It is no longer a correct statement of the law anyway. I'm not going to give it anyway. Okay. As I see it, we've got issue on S3. When does basically boil down to this? When a killing takes place, can the robbery come after the killing or not? Do you have to have the intent to rob when the killing is committed?
Your Honor, that's answered in Batiste.
In what?
Batiste.
I'm familiar with Batiste, and as I said, I think I know what the answer is, but I want to give both sides an opportunity to.
Paragraph 33, and the law is that
Go ahead and make a record on that while we're here on the record now.
T stands for the proposition that the intent of the robbery can be done after the murder.
Let me, have you got that handy there? I'm familiar with it. I want to refresh my memory. That's,
We've got a tie.
it,
I've got it.
that Batiste case is one of the preeminent cases in criminal law anyway. I'm gonna do this, Mr. Creekmore. Mr. Hill, I believe that this Baptiste case speaks as to what the law is. Unless you show me something to the contrary, I'm going to say that S3 is a correct statement of the law.
Are you giving me the Sunday afternoon?
I am. I'm going to give you an opportunity. I'm not going to require you to do it now. But,
Citing Gillette, 56 Southern 3rd at 492, Batiste at that site, 121 Southern 3rd, 808, says where the evidence, the time sequence of the felony and the murder is not important as long as the evidence and its inferences demonstrate one continuous transaction.
we don't have one continuous transaction.
The jury could find that there was, a reasonable jury could find that there was there's been evidence that Mr. Carpenter carried a satchel with him. The satchel, he was dead, and the satchel and the pistol was no longer there. I think a reasonable jury could infer it. They, on the other side, if the jury believes that that was not a continuous transaction, that's something you can argue anyway.
Well, yeah, that's certainly our position.
Okay, but
One continuing transaction.
I'm going to work under the assumption that I'm going to give S3 unless you provide me something that says I shouldn't, okay?
You'll hear from me Sunday afternoon.
Okay. That leaves us with the continuing transaction on the robbery issue that Mr. Hill's going to look at. And then D1, D2, and D5. The first question before y'all will be this: whether an alibi instruction should be given at all, and if so, whether it's separate and apart from just reasonable doubt, and if so, what instruction should be. And if y'all would, I'll give you Sunday to check on that anyway.
One of those three, 1, 2, and 5.
1, 2, and 5. The first baseline question is: should an alibi instruction be given at all, or is that just part of reasonable doubt that the court instructs on?
And I'm not sure that we've been put on notice that there was going to be an alibi. There was some, maybe 2 witnesses, but I haven't heard proof from either one of those individuals that were noticed to us by the defense. And
I don't.
or have we had opportunity to examine them. So I'm not satisfied with that.
Y'all be prepared to argue about alibi prior to Monday morning. Okay? Send me any law you want to before Monday morning, and I'll make a decision and put on the record Monday morning. Okay? What is required to, first off is the statement that like the text message is saying Daddy's cooking hamburgers. Is that sufficient to?
I understand that, and that may go to the element that the state has to prove beyond a reasonable doubt that on November 30th, 2022, that he was there in Tippecanoe to kill Kirk Carter. That may be proven to argue against that element, but I don't know if it necessarily constitutes an asserted alibi.
As I stated earlier, the baseline question is whether or not the defendant can receive an alibi instruction in this case, followed by, if he is, what should that instruction be? That's your homework assignment anyway, okay?
I understand the assignment.
All right. Anything else we need? Why don't we, while we're here, so we won't have to do it Monday morning, is if you're planning on getting up a closing argument, how long does each side want for a closing argument?
We'll do the same split.
What's that?
We'll use y'all like an hour. He wants an hour.
Did you say an hour?
I said an hour.
All right, hour it is each side. I'll let y'all divide it up. First half, second half can't be more than half. I'll let y'all give me some time. Y'all can get your notes together and decide how long you want.
However much time you need, I'll take the rest.
All right. Anything else before we break for the day, for the week?
Not from me, Judge.
All right. Court's in recess. ladies and gentlemen of the jury, I know emotions are high. We're coming to close this thing. Don't do anything to mess this court proceeding up. I'm not expecting you to, but everybody just hang in there till Monday and let's get this thing over with, okay? I'm just asking you to do that, all right? All right, court be in recess until 9 o'clock Monday morning.